You are listening to the NPZ Law Firm Show. Immigration woes, visa serve nos. US and Canadian immigration and nationality lawyers who speak your language.
Making immigration law easy and accessible for you and me. That's NPZ Law Group, a full-service immigration and nationality law firm in New Jersey, New York, Indiana, India, and Canada. I'm Vijaya, talking to Ludka Zimovchek, NPZ's partner and managing attorney. Hi, Ludka. How are you?
Hi, how are you doing?
I'm doing very well. Well, there's this question that's been on my mind, is that can an individual really obtain a legal status when entering the US with someone else's passport?
That's a really good question, and we see it quite a lot, and it is possible. So that's a short answer, but I'm going to go into details a little bit more. So this means somebody enters with a fraudulent passport. So they enter through inspection, they get I-94 hopefully, and then obviously they want to apply for the green card. So the question is, can I get a green card? So I think the key point here is to have a qualifying relative, and that's the most important. There is something called extreme hardship waiver. It's an I-601 application, but as I said, for that we need a qualifying relative. Now, who is the qualifying relative that can help with the waiver? Mm-hmm. That's a spouse that is a green card holder or U.S. citizen, or there has to be a parent that is a green card holder or U.S. citizen. Very important. Kids are not qualifying relatives. And oftentimes I see with my clients, they come very excited. My U.S. citizen child now is 21 and they can get green card for me. They're going to file a petition. So yes, they can start the green card process, file an I-130 petition, but once the time comes to actually get the green card, they will not be able to because children, even adult children, are not qualifying relatives for the purposes of the waiver. So we need that qualifying relative. That's very important. And then we have to prove that this qualifying relative will suffer extreme hardship if that qualifying relative had to relocate or move to the home country of the applicant, or if they would have to be separated for a really long time. How do we prove that hardship? Well, USCIS officers will look at different factors. So we need to prove family ties and impact. How long this person has been living in the U.S. What are the family? Do they have any family abroad or not? Mm-hmm. Social and cultural impact. Do they speak the foreign language? Would they be able to get a job? How about educational opportunities? Economic impact. Does the qualifying person have any type of child support they have to pay in the U.S., mortgage, loan? So we look at different things. I would say the most important are medical issues. Again, this is about qualifying relative. Unfortunately, we're not looking at medical issues of the applicant, but it's the qualifying relative. Also psychological impact, country conditions. So we look in totality how we can prove the hardship to the government. And then, of course, we have particularly significant factors. If we have those, then more likely the waiver is going to be approved. For example, qualifying relative is serving in the military or is disabled, or there's a family member that is disabled and our qualifying relative have to take care of them. So there are different things we need to prove. We need to provide a lot of evidence. Yeah. So, the key here also is not just to have qualifying relative, but also have entry document, I-94. Because remember what we said, the person enters with the fraudulent passport, but they still need I-94. So that's very important. The process can be done in the U.S., and that's usually the question. So that can be done in the U.S. However, don't mistaken with someone who enters illegally. That's totally different story. That's a different waiver. It's called provisional waiver. So if the individual just crossed the border, never was inspected, that's a provisional waiver that will have to be completed at the U.S. Embassy. It's not possible to do it in the U.S. There are few exceptions, but generally speaking, provisional waiver needs to be concluded at the U.S. Embassy at the home country.
Wow, lots to consider there. And thank you, Lutka, for bringing it to the fore on that. And of course, that's Lutka Zimovchek of the NPZ Law Group, helping you with the A to Z of immigration, from green cards, marriage cases to H-1B visas. Call them today at 201-670-0006 or just log on to visaserve.com and get a special discount when you mention Mirchi on your consult. More chit-chat on the law with the learned counsels of the NPZ Law Group coming up. We'll be right back. You keep listening to Mirchi, it's hot.
There you